Welcome to today's program. It looks like we're going to have a record crowd today, and so I just wanted to thank you for your participation. My name is Mickey Brock. I'm the current president of Houston LERA. I'd like to thank Jennifer Ortiz Prather with the EEOC and Walter Darr with FMCS for organizing this meeting and their presentations that they're going to do. And also thank Dr. Patrick McDermott, our featured speaker on the EEOC mediation. As always, we appreciate National LERA and Bernadette Tiemann helping us with the technical aspects of this presentation. I want to thank Moretta Tate for arranging for the Texas Attorney MCLE credits. And what we'll be doing is putting in the chat later in the meeting the course number that you'll need to use to apply for those credits. For the first time, we're going to be offering SHRM recertification credits. And so if you want that, we would ask that toward the end of the program, you put in your full name and indicate SHRM recertification credits. And then we'll get you some way to confirm that you have participated in this program. I want to alert you that on December 6th, from 5 to 7 p.m., we're going to have our first in-person event since the pandemic. And it's going to be at Lorenzo's on Washington Avenue. It's going to be a joint program with, it's not really a program, it's a holiday celebration, but with ACR Houston and TAM, along with Houston LERA. And you'll hear more about this in the next week or so, but we hope you can join us and celebrate the holidays, establish some new friendships and networking. It should be a fun time for all that participate. And if you haven't registered for this and or just happen to be on the program, it would be, and you want to hear more about programs that Houston LERA is doing, be sure and log into our website and register so that we have your email address. We won't get it any other way. And now I will turn the program over to Jennifer. And thanks again for your participation. We really appreciate your support for Houston LERA.
Thank you, Mickey. Thank you all for being here. Good afternoon. We are excited to have this LERA Zoom presentation that we've entitled Employment Dispute Resolution Revolution. This is a wonderful opportunity for us as folks coming from the federal community and have other folks not run away from us. So we're excited that we have over 73 and even counting participants with us today. This is an opportunity for us to share about our programs, how we have transitioned, how we have evolved, and really what we're really questioning now as some sort of revolution that is really occurring. And it's real time for many of us, still ongoing. I'm joined by FMCS Regional Director, Walter Darr. Walter, you say hi to everyone. He is a regional director now, and Walter is a fellow LERA board member. And this whole program came about because Walter and I started talking, what's going on at FMCS? What's going on at EEOC? And that's how it really got started, with so many changes going on. And it turns out that we've both been, our agencies at least have been collecting data. They've been collecting that data that we want to share with you today, and also ask questions about where do we go from here? Let's see where we're at, and let's see where we're going. Kind of take a pulse of the situation. Now, I don't know about anybody else, but probably definitely Walter, but I definitely have to call headquarters anytime I want to get data. And the good stuff is kept, you know, in that secret vault, right? And we have joined us here today, Stephen Ikniowski. He's with the EEOC, I should say. He's with our national headquarters office. He's our national ADR coordinator. He serves as basically our liaison and our chief mediation manager for the EEOC program, where all of the 15 district offices report to Steve. He's also actually the biggest champion of EEOC mediation. He began and started with the program in the early 1990s for us. We're also joined by Patrick McDermott. Pat is a professor from the Franklin P. Purdue School of Business Management, and we are really excited to have him here today to share with us all of the great work that he's been doing behind the scenes as far as collecting the data. Pat actually first was on the first evaluation team for the EEOC, and that began in 1999. So throughout this entire time, he's been collecting the data for us. And of course, this was a prime opportunity when we went online to start collecting that data online. So welcome, Pat. Thank you, Steve. I'm going to pull up the presentation right now. Walter, did you have anything you else wanted to add? We're kind of going to be chiming in, but we've got some data we want to share with you, and I want to put that on the screen now. Feel free.
Yeah, I'm great, Jennifer. I appreciate it. I appreciate the invite from LERA to participate in this, and looking forward to sharing some thoughts with you all and learning stuff from the group as well.
Sounds great. Thank you, Walter. Now here we have it. Can everyone see the slides? We'll do a slide check real quick. You can see it up on your screen. Yes. All right. Thank you. See if I can get the slides going. There we are. All right, Steve, this is for you to take away and spotlight.
Thanks very much, Jennifer. A very, very timely topic, interesting topic. And I don't know if you noticed over my, I guess it's my right shoulder. Yes, my right shoulder. There's a picture of Brooks Robinson. And I know in Houston, Alex Bregman is the third baseman of note. But just want to remind you who the greatest third baseman of all time was. Just, personally, of course. And again, you see, notice the orange. So there is some connectivity to the Houston group. Very, very wonderful series to watch. I know you guys are excited down there.
If he can help us win a pennant, we'll adopt him as a member of the Astros.
I think, well, let's just put it this way. Yeah, I don't want to show my age, but 1970 World Series, Brooks Robinson in Baltimore. That's all we have to say. Anyhow, again, very interesting topic. Glad to be sharing this locally, as we have been, Pat and I and Jennifer and some other folks at EEOC nationally. I don't think that when we embarked on these studies that we could have seen the multiple spin-off effects from the research, not just what Pat found out about EEOC. I think it's important to note that we shifted to from in-person to remote platforms out of necessity, as probably everybody has in the last couple of years. Mid-March 2020, we were doing everything by in person, and then from that Friday, I guess it was March 13th, of course, Friday the 13th, to March 15th, the Ides of March, we had to shift from in-person to virtual. We still had mediations in the queue. We still had people who were trying to get their discrimination claims resolved. But we really had only experimented and used alternative platforms when parties couldn't show up. So, we used phone when people could only use phone. We used Skype. We used a very bulky Department of Defense video system, which our federal sector administrative judges use. But again, you have to be in a place where you can use that. So it wasn't really portable. And then, of course, what we found is that while we needed something a little better to use, private industry came to the forefront in terms of Microsoft Teams and, of course, Zoom for Government, which is what we've adopted. But having said all that as sort of a preliminary, or as an entree to what we're going to talk about today, we soon became concerned about what the qualitative aspects of our mediations would be under this and under these series of new platforms, and Zoom is to be adopted. We had, as Jennifer referenced, done surveys.
Can everyone still hear Steve? He's going. Steve, if you could readjust, I think we're losing some of your sound. No, can we try again?
Can't hear him.
Okay, thank you. You wanna, no, Steve? Would it work out without the headset, or? Yeah,
Steve,
Okay,
you might
sorry.
need to.
there you go. I can hear you now.
Well, this is an EEOC headset, so again,
It's not related to our survey data.
not related to survey data. So where was I was going to say, so what we found out is that while our quantity of mediations, the stats were similar, we were very, very concerned about the qualitative aspects about mediation. And to that end, we went back to the drawing board, or we connected with Professor McDermott and Professor Obar to say, is there a way that we can somehow survey our remote participants in a way that gets to the heart of the matter and the questions about, is the fairness still the same? Is the neutrality preserved? Did you get a chance to be heard? All those substantive and procedural due process of things that I think all of us are concerned about. And while the results from that survey about EEOC were heralded by EEOC, and rightly so, I think what has really, and I don't really know how to underscore this, I think what was more amazing than the results, which is unusual for a government-sponsored program person to say, were some of the other findings that Pat found in researching this. And again, we're talking about just EEOC type processes, but again, EEOC's mediations involve every employer with 15 or more employees. Just about anyone who works in the workplace is covered by the EEOC law. So you get a real benefit of looking at everybody in a given area, and of course across the country, who participates in a workplace dispute, which covers just about everybody in terms of demographics. So what I found, while I was very, very happy with the results about our program ourselves, I think some of the comments, the specific comments that we found from participants in the open-ended questions really got to the heart of the question of what's the future of mediation? What's the future of dispute resolution? And are there certain trends that we found that could be applied to all types of dispute resolution mechanisms that are out there? And really, it may lead to a redevelopment as to how mediation is provided and how it's taught to people. So I think I've teed it up for you, Pat, if you want to take it from there. But again, we got into this to just evaluate our program, and which we did. But I think some of the more extended findings are important to this group today. And that's why I'm really happy that groups are starting to look at this. And LERA is at the forefront here. And I know Pat and I will be going to Baltimore's division of LERA, and we've been to the national conferences. It really is a topic that is still a little bit in flux, but it's trending in certain ways that I don't think any of us could have foreseen 3 years ago. So Pat?
Thank you, Steve. Let me set up the next one.
Thank
Go ahead.
you. I'm ready to roll here. Yes, and shout out to everybody down in Houston. In my prior life, I used to represent ABC Disney, so I would handle the KTRK account and go down, and KTRK cares about Texas. If I had my mug behind me in my shirt, but I'm not in my office today, but I have that in my office and have fond memories for Houston. It's a great part of Texas. Yeah, the thing that Steve set up, I think it's really fun the way it happened, was when persons were talking about going to the online processes, immediately there's discussion of digital divide, technology difference, et cetera. And so we saw a perfect example that which Steve did today, where he had an initial issue. And one thing that our data found, because it was basically about the only thing that there's reporting of some issues with, was like an initial problem maybe with connection or the technology. And we analogized it to like when we were young, and some of you may not recall this, but we had rabbit ears, and you'd adjust the TV at the very beginning to get the program right. And sometimes, you know, you had to stand up and hold the antenna. Your parents would say, keep holding the antenna. This is a perfect position, right? And in some ways, that's often what would maybe happen at the beginning of a mediation. But just like that, kind of like the television program, everybody forgot that and watched a pretty good program, but a pretty good outcome. And that was one of the things that we found, and we have a lot of hard data as to what I mean by the good outcome. We know conceptually, it's really fun to speak to professional neutrals, to advocates, to human resource professionals, agency professionals, to really discuss what happens for most cases at the EEOC. How do I know? My last 20 years, I've done plaintiffs' employment litigation until I recently moved on to the FMCS labor management panel. But I litigated first representing management and private employers in a law firm, and then representing plaintiffs when I entered the academic world. And the one thing about the EEOC is that usually, given the caseload, for most of the clients I had, if they didn't have me, it was going to be difficult for them to vindicate their rights through an agency investigation. It's just a very difficult process for a lot of reasons. But what was also interesting is that the EEOC mediation process always provided a separate opportunity for persons to pursue their case, to meet, and to, in a sense, almost have a funny form of an investigation. I say a funny form that I'm not claiming it's an investigation, I'm not claiming all the documents are turned over, but people get to tell their stories. There's responses as to what happened in the workplace. There's a dialogue, and then people decide whether they want to resolve the dispute or fight on. And all the legal empiricists, and the late Ted Eisenberg at Cornell led a lot of this, all of your data shows that it's almost impossible, literally almost impossible, to prevail in plaintiff employment litigation through the federal court system. Now, some litigants now go into the state systems. There's other ways of litigating, but it's a really tough haul for the average person. So one thing that's exciting is for the right persons and right employers, this is a valid alternative process.
And Pat, I think you had, in one of your articles that I read, it had quoted about 3%, is that right, of people will actually make it to court, not necessarily successful, right? Is that what I read?
Yes.
And that's still the study. So.
And my last case I had, for example, was a Fourth Circuit Court of Appeals argument, a disability discrimination case where we were able to prevail, which one we were lucky because we got the right 3-judge panel. But usually, and the only reason we could do that is because I'm a professor, so I have a separate income, so I can do this as part of my overall service, pro bono service to the community. But it's just incredibly expensive for the average person, and this is just the real world we live in.
Yeah, and I think it's important for the audience. Sorry, Pat, just to underscore that this is part of the EEOC process before the investigation begins. So that's the mediations that we are focused on. That's the majority of our mediation services to private sector entities that get served with a charge. So still we have about 30%, maybe slightly under that, of folks that are served, respondents, companies that will actually agree to participate. So we're talking about a very thin sliver here, but we've had some tremendous results. And just to give you an idea, during the pandemic, this time that Pat's going to share some of the information, and I've already started to put it up here, of when he took the surveys, just in Houston, from March 15th, 2020, we conducted over 900 mediations, and we had 680 resolutions. During those resolutions, we had obtained over 18 million in monetary benefits, and that's just in 2.5 years, with an average of 3 full-time mediators. You know, you can imagine, just like your staff, our staff has been in flux, and that includes 14 contractors and pro bonos and myself. So that's, you know, kind of the numbers that we're dealing here for the Houston community with EEOC. I just wanted to add that.
That's very helpful. And the one thing before we get into the hard data, which you'll see is just very, very positive about the program, is the way we gather the data is also important, because as a critical thinker, you always have to say, is the researcher independent? What do they really know about the process as they're asking the questions? So it was really fun because I participated in EEOC mediations for years. I'd evaluated the original in-person program. I participated in federal settlement conferences, et cetera. And then I attended the conferences during COVID where all kinds of things were breaking loose. We didn't know how we were going to adjust. And Cornell had a great conference online on this, as well as LERA. And you had comments online where some person said, I think there's Zoom fatigue. Somebody else had a comment, oh, I can't read body language. And I just listened and I would take notes. And I would just listen to all the practitioners talk about all the reasons they thought the online video mediation was good, was not good, et cetera, and said, okay, I'm going to measure it. And then what we did is we developed these survey instruments, which we then offered to each participant immediately after the mediation was over with email follow-ups on a range of questions. We also surveyed the mediators. So we had a detailed survey. Do they see offers coming out faster? Do they use caucuses differently? What's the velocity of the negotiation? How about the flexibility of bringing persons in? So we just had these wide range of measures from the mediator's vantage point and from the participants' vantage points to say, hey, what's happening in this new arena, and testing it against what people thought would happen. So our results, of course, show that from a procedural distributive justice perspective, procedural is pretty much, you know, what you heard, did you get a chance to tell your story, et cetera. And distributive being outcome driven, you know, was it overall fair? Did you feel as though you had a fair outcome? Now, remember, in mediation, if you're a scholar and anybody tells you they got a 100% fair outcome, you have to worry a little bit in the sense that it's a compromise, right? Nobody should come away saying, I got everything I wanted. They should kind of both feel wounded if you have a good negotiation process. So we ask and we recognize your distributive outcomes are always going to be lower than your procedural. So you pay attention to both. Next slide.
I'm trying here. Got the button.
Take your time. And I'd love questions too. So if anybody wants to jump in and ask and tell me
There
what
we
I should
go.
have asked that I didn't, I'm happy. I'd love to hear what we didn't ask that we should have. And by the way, Dr. Obar, my partner who's in the Philippines, she's just a wizard. She's my statistical partner and wizard who puts all this data together. We're actually working with St. John's University School of Law to give them some of our data to let them do research studies. And I would say to any academics on the call, we have a very, very large database that we're happy to share should you want to do your own individual research to focus on certain areas of this process. There's our outcome satisfaction we see is higher than it was for the 2000 in-person rate. So again, you've got high measures of these processes. Next slide. This is the key measure that we looked at back in 2000, and I think it's still important, is you ask the charging parties and the employers, would you use the EEOC mediation process again? Would you use online? And of course, they're very, very high, and that's your best satisfaction measure. Depend, you know, maybe the headset didn't work, maybe somebody's horn was beeping in the back, the baby was crying, the dog was barking, but people were happy with the way the process played out. And the most interesting thing is most employers, you can see the employers said it made it more attractive for them to participate. Why is that important? If you think about it, that's a backdoor access to justice measure. Employers are more willing to come to the table because of the economic efficiencies. It's not that they weren't coming to the table before out of bad faith, but because businesses have to balance the costs and benefits of these processes. When we move it online, more people can participate, and therefore it gives the charging parties, I would argue, a shot. So you actually allow them to get on the field of negotiation, so to speak, as opposed to just sitting back and hoping there's going to be a positive investigation.
Pat, could you speak to the size of the survey? I believe it was over 2,000.
Oh, yeah. You know, the two things I never get right is when people ask me how many students there are at my university and what was the sample size of the survey. It was thousands. I always like to put it this way to make it easy. The first survey in person in 2000 was the largest database ever collected on workplace dispute resolution at the time, and I think thereafter. And this one rivals it in size, so that we've got so from a statistical perspective, it allows for robust data. Very, very large. This is not the law of small numbers by any means. Had a really good response rate. And that's given the fact that even with the follow-ups, you're still captive to, did the mediator give the correct email address, right? Because if the correct email address isn't correct, then it bounces back. So we had to deal with all those procedural aspects of trying to make sure everybody was able to participate. So very, 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 very robust participation rate in data.
And nationwide, right, Pat? Because it was from our
Yes.
different offices that we had, you know, complete variation from Chicago to Florida, California, New York, and of course, Texas. So everybody in the middle.
Well, the one thing I'll say about this country is almost every place there's an EEOC office, there's a place you have to drive to that people would prefer not to, and a place where you have to pay for parking that costs more than it probably should. So right there, a lot of people will say in their comments and all, yeah, it's great to avoid the travel and the cost of parking and resolve my dispute. So in some ways, we're all the same across this wonderful country.
Absolutely. I'll let you get to this next slide. It looks like I've got it up on the screen now.
Yes, when we asked, because I always thought the money question was really to pit in person versus online. And of course, that goes to the heart of the what practitioners think. And it's kind of like saying, you know, do you really want to see the mediator in person or not? And some mediators at the time we did this really wanted to be in person, and that was their shtick, so to speak. But a lot of the participants said no, they'd actually prefer, we call it ODR, you could call it really online video mediation, but they were okay with this online process. And I think that's very reassuring for the practitioner, because I'm not sure you really get a chance to ask that question like you'd like to in the process itself. But they said, no, we're fine. And only 13% preferred in-person mediation. So you had some that were just in the middle that weren't sure, but 70% said they preferred that. Now, at the time we gathered the data, and this is what makes those open-ended questions so valuable, and that Steve Ignaski mentioned, is that COVID was still lingering. And far be it from me to declare when a pandemic is over or when it began or anything like that. But the fact is, some persons would comment, of course we prefer online, you know, there's COVID out there. But that wasn't actually the majority of the feedback. So what we academics like to do when you put on your academic hat is it would be great to retest this somewhere down the line where you don't have pandemics or persons still concerned about being exposed and getting sick, to retest some of this data in the perfect pandemic world. But I can report very confidently that while some of that data relates to the fact that there's the COVID pandemic, most of it actually reflected on the higher quality processes. And that's also what the mediators said. And so we call that triangulation of data. When you have participants saying it's a more flexible process, you can quickly bring in witnesses, you can do a one-shot reconvening that you couldn't do before, because you couldn't say, hey, everybody take a break at lunch, or, you know, or can we get back in 2 or 3 hours? A lot of times you need to keep people corralled when you're in-person mediation. It's just all kinds of levels of flexibility that made it a more desirable process. We found that money was a big issue. That's pretty much no surprise. What was fun, and I commend the EEOC because they allowed me to ask any questions I wanted to. And I've evaluated the TSA's conflict system, the EEOC before, the state of California. And building a trust where you can ask whatever you want, because sometimes agencies are afraid the answers they're going to get which I argue why, but that's the nature of the world. But they allowed me to ask whatever I wanted. So I really wanted to see, okay, what was the spread if there was impasse? And the one thing I found, and kudos to the EEOC mediators, is usually there was a pretty far financial spread. And I report that in the study, but basically, if it's anywhere with a few $1,000s, I think it was even like $5,000 spread, the cases got settled. So the mediators were able to bring most of the horses to water and to get them to drink there if it was close. So
And I think that bears out. Oops.
Go ahead,
Okay.
please.
I think that bears out too with the overall, right, Steve, the percentage of resolution rate was still maintained at 70%, more or less. Is that right?
Yeah, I mean, again, going back to previous comments, the statistical parallels were so close. But again, we were worried, was that just by necessity, or do people prefer it? And again, that's why I think the information about the qualitative analysis in some ways is much more important than the data. We always get hung up on data points and metrics and things of that nature, but if the quality isn't there, you wonder if after certain things, the events are over, will they still come back? So yeah, in terms of workload and those type of things, those more neutral aspects, it's similar or same, if not better in some areas.
And what I would throw out, because this is, I'm not in this study, we're actually pitching the party satisfaction, the efficiencies, et cetera, because the data supports it. Fascinatingly to me is that the settlement rates are the same, which gets into the whole different thinking of, is there in fact a maximum settlement rate under some type of like Fibonacci curve, where no matter what you do and how you do it, in an initial mediation, you're going to get about X% of people settling, which then makes you wonder to what extent the mediator is bringing about the settlement, or whether there's a natural curve moving towards a certain settlement percentage. Way beyond the research I've done to date, but I think interesting. Of course, now with this online tool, that then challenges the EEOC to say, wait a second, if we've got X% settlement rate on the first using this tool, don't we have options to move some of the more difficult cases immediately to maybe a higher process, or another process that may be able to bring in another 10% resolution?
Right.
Or alternatively, and this is something to remember too, when we say there's a 72% settlement rate, sometimes, and this is true for the EEOC data, you never really know the true settlement rate. And those of you who are management attorneys like I was, when we cut deals on the side, a lot of times we didn't call the EEOC back to let them know. And this includes when you went through a whole mediation with the EEOC, et cetera. So we always call this the hidden benefit of the program that you don't see. And a settlement could actually be for a case in another area, because when I litigated, I would pair a Sarbanes-Oxley case with an EEOC case, et cetera. So sometimes bringing people together, you see that 72% settlement rate, but you really don't know. And I can't report as an academic because I can't do a longitudinal study to call people up and find out what really happened 6 months, a year later. The funding is just too high. So hopefully that insight helps. It's a little tricky.
Yeah. Pat, I think this is especially important. If you think about where we were at before the pandemic, where we thought that mediations, it was a requirement at the EEOC that you came to our program, and that we had both sides there in person. So, of course, I would have thought, yeah, no one wants to have parking, no one wants to go through that, but it was worth it, right? In the end, because we had such high success rates. But what happened during the pandemic? We were allowed to mediate. We had to, for better or worse, embrace this system. And when we did, it really was shocking to me that it did not drop off. The levels of settlements, the settlement numbers actually increased. We got happier mediators because they were also managing the issues with the pandemic. And it's interesting to think about, what will we do next? where are we going with this? And will we be able to get people back in person? Is that going to be, are we ever going to go back to a requirement like that when so many work offices are virtual now? We are a reflection of what we served in mediation. All of us here essentially make money from conflict and change in the workplace, right? We are somehow tied into this. And it's going to be really interesting to see. I know, Walter, I've kind of left you out, and I do apologize for that. There's comments you want to make, and I think you might have some slides. Is that right, Walter, as well? And also, Steve, if you want to comment on any of this as well.
Yeah, no worries. And I've not jumped in. I do have just a few slides and some info to share from the FMCS when y'all finish up. So I'm good.
All right, Walter.
Hey, Jennifer, the one
Yeah.
thing, and Walter, the one thing that I found interesting, and hopefully the FMCS has seen some of this, is that when we looked at our data and then we looked at some of the open-ended responses, I actually was shocked at how many persons were uncomfortable coming to a government office where their employer was in the same building, because maybe the nature of the underlying dispute could have been sexual harassment case, could have been a power differential, but I never would have thought that there would be as much feedback where person said, I just feel so much safer in my home. We talk about safe space these days, but that's like a really added benefit that just kind of leapt out of some of our data, including the qualitative data.
Yeah, I experienced, actually, we had individuals who were coming to mediation, participating online with their phones, right? Because some of you may be doing that right here, just to participate in this presentation, but they were able to access online with their phones, and it would be a mom or a caregiver, someone who's kind of in that sandwich generation where they're dealing with an elderly parent and young children, and didn't want to leave them unattended to go to make the extra trip to go downtown or have to meet at the attorney's office or any of that. And they were able to participate. And I hadn't really thought about that population, that segment that we really weren't able to serve before we had this online mediation.
Jennifer, I don't find that surprising at all. We have not kept qualitative data on that, but I will tell you that part of the reason that the FMCS didn't co-locate in federal buildings was a lot because of those types of issues, which is why when we do still have some FMCS offices, you see them in private office space rather than located in federal buildings.
Yeah, I think that makes sense, Walter. Something that happened to us in our building on the 6th floor, we are co-located now with the immigration courts. And so that does have an impact. Not only that, but we've got other things in the building. And so there's, of course, these are just our realities that we have other populations coming in and out. And it can, I should say, send a chilling effect. And I don't think we've realized how, we are now giving people a new option. And I think that's going to make all of our programs better when they can embrace this a little more fully, our technology.
And if
Did you
one question I'd like to ask the practitioners out there, and if there's some union representatives, et cetera, this is the EEOC. This is just the mediation online video for the EEOC. But have you thought about how you could reduce the cost of grievance handling in the workplace, the cost of arbitration, or the cost of other dispute resolution processes, given the data that we see here? Because that, to me, is the next step, is how generalizable does the audience think some of these processes may be to benefit the workers they represent or the clients they represent?
Just looking at a couple of questions. We have a question about, did you have previous work with persons with disabilities? And do you have a sense from the surveys, if persons with disabilities felt online mediations impacted their need for accommodations? Did it help or did it hurt? I think that's an excellent question. Thank you.
What we always did, we did it in 2000 and we did it this time, is we always run the data by basis so that we get all the different bases. And in fact, one of the scholars we're working with wants to see a certain basis and how the data lays out there. Our data, by the way, if you're interested in doing research as an academic on just that disability basis, we're happy to share that slice of the data. All of it's come out to be similar, the results, so that there is no distinction. Then when you get to some of the comments, which are open-ended, you could argue they're not anecdotal, they're considered data, but it's a different type of data, qualitative data. Persons commented that because of their disability, it was easier to participate. And that was something that, quite honestly, I had never thought about in this process, and probably worthy of even more analysis of to what extent this process actually opens up the process to more people. We can just think logistically, if you're disabled, it would be easier to be in your home than to try to make the transit to wherever the mediation is. But then there's other issues as well. That's a great question, though. We do need to do more research on it.
Thank you, Pat. I want to give Walter some time here. Walter, did you want to go ahead and put up your slides then right now? I think you have co-host ability and are able to do that.
Yeah, I think actually Bernadette's gonna maybe throw them up for me.
All right, then.
Or throw them
can
up.
go
Maybe
ahead.
that's not a good way to say it. Sorry.
Not too fast, at least. And if anybody has any questions, please put them in the chat box. I am monitoring that, and we will hopefully have a few more minutes after Walter's done with his slides to maybe ask a couple more questions, get to some of the questions in the chat box as well.
Is that showing up for you now?
It is, yeah.
I see it.
Yeah, so
Whenever you're ready.
Okay, great. I'll go ahead and jump in. Sorry. Yeah, thanks for giving us the opportunity to share some information. And so just, I think just about everybody is familiar with the FMCS, but I'll just take a couple minutes to talk a little bit about kind of what we do as opposed to the EEOC's mission. Give me just 1 second here. So our agency, if you want to flip it to the next slide there, Bernadette, that'd be great. We were created in 1947 under the Taft-Hartley Act. For those of you that aren't familiar, we're neither a regulatory nor an enforcement agency. Instead, we're a neutral agency that was designed to assist labor and management. For those of you sort of labor management buffs out there that have dug in, there's a lot going on in the late 40s, a lot of strikes, a lot of lockouts, and basically our positions in our agency was created to help get interstate commerce moving again and get ensure that workers were working and companies were producing, and so that was our initial mission, which was really collective bargaining mediation, right? When parties had a dispute over a successor collective bargaining agreement, and that was all we did in the initial part of our existence. You can go ahead and flip to the next slide if you want. And so we help parties resolve collective bargaining disputes. Anything that threatens the free flow of commerce. Some might say, well, what business does the federal government have involved if a private entity can't reach an agreement with his union? Our interest is interstate commerce, right? We want to keep things flowing, keep the economy going. And then also since that time, our role has expanded where we now have made our services available to other federal agencies, helping them resolve disputes. We do some work for several agencies prior to things making it to the EEOC. So several agencies have internal offices that deal with initial filings, and in those agencies that we have agreements with, we will have a mediator come in and typically do a half-day mediation to try and help the parties resolve the underlying dispute. And then if we can't help them resolve that, then it carries on through its normal EEOC process, and neither party loses any standing. So if you want to flip to the next slide, Bernadette, that'd be great. So promoting sound and stable labor management relations. We want to prevent or minimize work stoppages through the intervention of a mediator, helping parties get deals. And we are, advocates for collective bargaining mediation and then arbitration. And while we don't have arbitrators don't actually work for the FMCS, we are really the premier arbitrator clearinghouse for those arbitration requests that come in by parties. They're seeking an arbitrator that's listed as an FMCS arbitrator for a panelist. So I'll flip to the next one there, Bernadine. We have, since the FMCS's inception, we've grown I would say a fairly robust ADR practice, and are introducing a lot of parties to ADR, from labor management forums, labor management committees within organizations, both private sector, public sector, and federal sector. We provide a myriad of conflict resolution services through our training department, through the FMCS Institute, and we really work hard to foster improved labor management relationships through our departments to help parties really grow between contract negotiations, right? To help them solve problems so that they don't become contract issues. And then in hopes that relationship will then spill over into collective bargaining, and that parties will be able to get agreements with each other with less angst and less hardship. So let me share some stats that we've tracked since we were in the same boat as the EEOC. Really, we were an agency that had really a face-to-face practice. We either hosted meetings at our offices, or we went out and participated at the party's site, but very much in person. We did have some virtual meeting platforms that we utilized. Ring Central was one of the first that we used. We used those really to bring in a subject matter expertise if we were doing a training or we were doing a specific type of a negotiation where we may have had a commissioner in another city or another state, and we wanted to sort of bring them into the meeting for some limited time. We were using some of those virtual meeting platforms to do that. But when the pandemic hit and the shutdown happened, we basically went from probably mid to high 90% in face-to-face engagement to 100% online engagement, and really kind of had the same thought process I think that Jennifer shared earlier, and that was, oh my gosh, are parties going to be willing to adopt an online presence from us, an online presence from the mediator, an online presence from their participants, and what's our world going to look like as we move forward? And so if you want to flip to the next slide, Bernadette. And so here's some stats that we've been tracking, and these, we have tracked really the quantitative side of it versus the qualitative side. We don't track agreement rates. We didn't track agreement rates prior to the pandemic for in-person mediation. And so we didn't start tracking agreement versus not reaching agreement, post-pandemic. But we basically got here what I'll share with you, 519 days of data that were collected, and to sort of put a sense on it, some pretty big numbers on a nationwide basis. A little over 19,600 total sessions. That comes out to about 38 a day if you're doing it 7 days a week. And through those sessions, we saw almost 380,000 participants, which equates to an average of a little over 19 per session. And then the real sort of mind-boggling number is the total session minutes when you aggregate them over all the sessions over all the participants. And so we have, you know, a little over 26 million total session minutes, which is about a 70-minute average per attendee per session. And so, you know, I think we would tell you that, you know, while there were challenges, certainly that had to be overcome, moving from a face-to-face engagement agency to an agency that went to 100% virtual engagement, our services were still widely accepted, at least while folks around the country were still operating in a bit of a virtual world themselves. We've now gone back to face-to-face. We believe there's going to be a continued presence of virtual platform meetings. Some of the other federal agencies that we have contracts with, for which we provide employment mediation, pre-EEO mediation, grievance mediation in some cases where there are federal and state employees that are represented by unions. We're finding that those agencies are still wanting our services virtually versus in person. We believe we have a high success rate in closing those cases with a positive outcome and an outcome where there's an agreement versus no agreement. We think that those agencies agree with that based on their continued use of our services, and we contract to those agencies for those services. And you know, candidly, we think that they're probably now leaning towards the virtual platform versus the in-person platform because of the benefits that it has to their employees who are often not co-located. The supervisor or the next level supervisor who's hearing the dispute from the aggrieved and the grievant themselves. And then also there's no longer a need to cover any ancillary costs related to our commissioners traveling to their location, right? So no mileage, no per diem, no airfare, no hotels. And that was all stuff that we would bill for on top of our services. And so quite a nice ability to avoid some costs by the agencies by staying on a virtual platform. We are seeing a strong move now in terms of collective bargaining mediation, where those parties want us out there face to face. We do still do some of those cases through a virtual platform, but that number is dwindling as time goes on. And I think we could talk about the effectiveness of those cases versus the effectiveness of the employment mediation cases. So anyway, I just wanted to share some stats with you kind of on what we've tracked. Once again, we have consistently tracked pre-virtual platform, the quantitative piece. We have not tracked the qualitative piece even pre-virtual platform, and so we're not tracking it since we started using a virtual platform. So I don't have agreement versus non-agreement stats with you. Nor we do some surveys to groups, and we're doing more of that now, and we'll continue to do that even with our in-person, and just asking them to assess the quality of the services they received. But we weren't heavily engaged in that during the time we were doing most of our work through a virtual platform, and so I don't have information to share with you on that. So I'll be happy to answer any questions that anybody has. And Jennifer, if you or Steve or Pat want to weigh in, I'm happy to have you do that as well. Whoops, you're muted, Jennifer.
Yes, Walter, thank you. It's important to share the differences so people can really understand the really big differences between the two agencies. I did formerly work at FMCS before I came to EEOC, so I can sometimes get them both confused when I'm talking. But it's really important work, and there are some things that I think we have discovered at least at our offices, and it's about confidentiality. And I kind of wanted to raise that. You know, we all thought, I think here, that confidentiality might be one of the biggest things to be undone during a mediation process. There were so many talks and conversations, I think, prior to us really deep diving in. And I just want to ask everyone here, how many times have you had any confidentiality issues raised? Have you had many of those breaches or other things, those kinds of fear, I think that we were reacting to? Did you see much of that, Walter? Or
yeah, so I'll weigh in. So one of the issues that we saw was the hosting of the session and the perceived impact on confidentiality based on host. And so what we did very quickly was adopted I guess I'd call it a policy, although we did show some flexibility when it wasn't possible for us to meet the needs of the parties. We basically said, if we're involved, we're going to take over hosting. And it's as, it's as small as, what somebody thinks can happen that we may know as users can't happen. And it's as big as when I go in a breakout room with my advocate, who's listening in? Can anybody listen in? And we felt like parties just felt more comfortable if it was, while it was Zoom or it was Ring Central or it was Microsoft Teams, parties felt more comfortable if it was hosted by us, that there wouldn't be anybody, quote unquote, lurking in those breakout rooms, although we know that's not possible unless you're some type of a hacker that, that could do it. The systems don't allow it themselves. And so didn't see a big issue with that. The other thing that we adopted very early on was basically terms and conditions agreements that we sent out to the parties, setting expectations on recording, what would happen if that happened, and things like that. And we actually had the parties execute those agreements and return them to us. So that I think both of those things were helpful.
Yeah, absolutely. Steve, did you want to make any comment on that? Because I know nationally, right, we had to kind of, we were starting from scratch. We very quickly changed to Teams. I think my kids in HISD got Teams before we had Teams at our agency. So yeah. They were teaching me while we were transitioning.
Right. I mean, in addition to the similar things that FMCS did, Walter referred to, like changing the agreements and making sure we also emphasized to our mediators, of course, to set the ground rules, and that evolved as our format changed. One thing that I don't think gets a lot of attention is that I know that when we were trying to figure out what platform to choose, EEOC approached Zoom, and primarily for investigative purposes, not the mediation program. And then at some point they said, we'd like to talk to your ADR folks. And I remember having meetings with, I guess these guys would become very, very important within Zoom because it was a kind of a fledgling operation when we started with them. And we had a lot of detailed meetings about things that they didn't even consider. And while we were having those considerations addressed, there was that week-long period where there was an indication about whether the Zoom platform itself was secure from hackers. And so they developed even more security related programs so that what we have at EEOC and what's available to the government is Zoom for Government. In addition, during those conversations, they wanted to make sure that it was accessible for a lot of people. So they built in even higher protocols for people with hearing disabilities, sight disabilities, those types of things to make it more accessible for disabilities. But also, was this a platform that could be extended to phones? And so they found out there were some glitches with that. So I don't know what the government, what influence the government had in terms of Zoom's overall product, but I can tell you that some of the enhancements that we see across the board were discussed during our conversations with them in our smaller ADR group because of the confidential information. My guess is that the confidential information cuts across to other industries too, like remote health conversations or other remote legal conversations. The other thing that I find very, very interesting is that with the reluctance in going to non-in-person type platforms was it took a while, but courts are really starting to embrace it because they recognize that their civil caseloads had to be moved along with what their criminal case. Now, pretty much the criminal stuff is still done in person, other than things like the things that were done video, but they're better video systems. So I think as the program evolves and as certain things pop up, we'll fix them as they come. But the initial ones, we wanted to make sure that it was secure enough so that people would believe it's secure enough so that they would entertain the possibility of going to a remote mediation or video mediation, as Pat calls it.
Thanks, Steve. It looks like, Pat, you just dropped in a paper. Is that right? Tell us what you dropped into the for everyone. I think you're on mute.
Yeah, just for redundancy, which we professors always like to do, and lawyers sometimes before a judge, which they don't like. But earlier, in the second slide, the papers, you can link to all the massive data from the EEOC studies. There's a lot of data answering a lot of questions. So on the EEOC websites. Then there's 2 SSRN papers, Social Science Research Network papers I posted for those who just want to look at the paper. I just want to make sure people have the information out there. And one of the pieces flowing from this research actually is being published as we speak by the Sorbonne in Paris, France. The French are very interested in the results, and they solicited me, and that paper is going out. So that's the top employment law journal in Europe. So that's kind of fun.
That's excellent, Pat. Congratulations.
Well, you guys
we
put the results in the work, so I just reported the facts.
We are going to be, I think, hopefully sharing some of the slides. Is that right, Pat? I think you just went off camera, but if we can get you back, I think we can share those slides, and if we can, we'll send that out and put that out. Is that okay, Pat?
Oh, sure.
Or
You can
Bernadette,
share.
or whoever wants to send it out to everybody. We're about to, I think we're in the process of probably wrapping up. We did get some questions about how to become an EEOC mediator, how to become an FMCS mediator. We really do refer you to our website. So there's a different process for both. And depending on what region or area you're most interested in. There's also contracting positions that are available, but that's on a 5-year cycle for EEOC. And that way, if you did apply for that, you can maintain your private sector businesses and also possibly serve as a contractor. But that process is not up again, right, Steve, until what, 2024? So we had the last one close in 2019, I think.
Right, we have one more year, one more option year under the current. And so 2024, like February of that year, there'll be a posting. And what is it? It used to be Commerce Business Deal. I think it's Fed Biz Ops now, right?
Yes, that is for the contracting. You have to have a SAMS, and you'll have to Google this kind of information. You could give a whole presentation on just how to get a government contract, but that's definitely for another time. Or USA Jobs, that also is the website if you're ever interested in the different conflict resolution positions that are available, not at just our agencies, but across federal government. That's available as well. I do want to have a wrap-up question and really ask, Walter, Pat, and Steve, where do you see, what do you envision when you think about the future of mediation?
There's a little lag time from Houston to Baltimore, and a little lag time up here too. Again, what I would say is, who knows, number one. But what this has really proved to be instructive for me on the level is that not to foreclose any possible growth. I think we were in that box of it only had to be done this way and with this methodology. And what we're finding is that we really have, and it sounds trite, but if your participants want something and it's consistent with the statutory constructs that we operate under, we actually have a law that says what is legal and what's illegal. FMCS provides the service, and as long as it's consistent with their mission, I think we have to be more open to be mediators between what our clients want and what we can provide under the laws we enforce. That's the big takeaway for me, and not to be so boxed into what we've done in the past.
Thank you, Steve. What about you, Pat or Walter? Who wants to go first?
Yeah, I'll jump in. So I think for us, there's going to be a portion of our clients that are going to stay in the online platform. They've embraced it. It meets their needs, whether it's associated with defraying some of the costs that would typically be associated with us being involved. costs associated with with some federal agency contracts we have, what we might bill them for, mediator related travel costs specifically, or with private sector individuals, costs associated with moving all of their employees to a single location to have a face-to-face meeting, right? And so I think some are going to continue to embrace that, and they're going to stay in that mode. And I think others are going to, what we're seeing is others are going to go back and say, no, we want face-to-face. We don't think this online is as effective, and can't really put my thumb on why, but it doesn't feel the same, taste the same, smell the same. So we want to go back to the old way. And so we'll do a combination of both going forward. And we'll really let that be driven by our clients largely.
Mhm. That sounds good. And Pat?
I think of it in terms of the students, and we're in these debates right now about the Gen Z students and how they like to be taught, what they need to learn. Young people like efficiency. And I'm sure there's somebody that's cooked a grilled cheese sandwich while they're at the same time attending this presentation, or they're billing time somewhere else and getting a lot done. So I think the future of work is really what's going on. And I think it's going to be driven by younger people that won't ever answer a phone call that I make anymore because everything's text. And it's going to be exciting, and just hats off to all the practitioners. And Walter, your agency, hats off to FMCS. I have a lot of friends there. I took your Becoming a Labor Arbitrator course, and I would say to anybody who's considering that career, the FMCS training is exceptional. So it's been an honor to be here with all the professionals and everybody out in Houston. And I just want to know how that grilled cheese sandwich tastes and how much time you bill.
You've done a great job. Thank you so much, Pat. I think, when I think of this question, I already want this stuff. I want the mediation app where I can just, file a complaint, where we can actually have these conversations. I want it separate, apart from my agency, so I don't have to worry about any of that stuff. I want to see somebody mediating in this metaverse that I hear about, and I have not been yet, haven't been invited to that. I want to know what our kids are doing, because I think that is the key, like you're saying, with this Generation Z, alphas, the betas, all of these new folks that are coming into this world. This is their platform. And I think to some degree, agreeing with Steve, we have to get out of the way and kind of think about that. If folks think I'm the youngest person in the room, there's a problem, because I am not. I guarantee you. And I know when you guys walk into other rooms, you have to, open your mind in different ways. And that's appealing both to the generations, above and below us. And it's just been a real pleasure to work with everybody today. As you guys can all imagine, out there in our metaverse, or wherever you're grilling your cheese sandwiches, right, Pat? It can be difficult to put these on. And so it's a testament to Bernadette from the national LERA, but also Mickey and Moretta at our own local LERA. I do encourage you, any of you, we have a great rate for LERA members. It's $10, only $10, right, for the rest of the year. We're going to have that happy hour holiday social, and we'd like to meet and talk to each of you personally about where you think things are going for the future, because we are here to create it. It's everyone here on this kind of call. The fact that you're taking time out of your day means you care about this stuff, and we're glad that you do, because we are going to be relying on you and everyone here to make a great workplace, hybrid, whatever we're doing for the future. So thank you again, Steve. Thank you, Pat. Thank you, Walter. And thank you, Mickey. I'm going to turn it around, and everybody, I think you're cleared to go. Have a great day, everyone.